Thank you so much for everybody joining us. Bismillahirrahmanirrahim. Basically, we're going to talk about the importance of Islamic state planning and why it is important for Muslims living in the United States. Small disclaimer, this is for the information basis only. And second thing is, if there's any personal question, please have it one-on-one. We do not want to share anybody's personal information in a community gathering. And so we hold liable.
Ji, Assalamu alaikum. This is Nasrullah. Can you hear me?
Yes, we
Can
can.
hear you.
Okay. Yeah, I'm sorry. I joined by a few seconds late.
Just
I'm
start.
just trying to wrap my head around by knowing who is who here, and I will not mind knowing who is the speaker, and if you can give us a little bit of a background. And we appreciate your time and you coming online, just so that we can just create some relevance to the whole discussion.
Nasrullah, all the ladies are there at Sister Shima's house. Me and Atik, we are sitting together. Hussein and Aftab.
No, I was talking about the speaker. I know you guys.
He is just going to start his introduction. He just started.
Okay.
So it's just a start. Brother Yasser, you go ahead, please.
Sure. So great question, sir. Who am I? मेरा नाम यासिर ज़िया है और इस्लामिक स्टेट प्लानिंग हम कर रहे हैं पिछले तकरीबन 2011 से. I am located in Maryland. My background is I've been a financial planner since 2007. Or majority of our clientele is in Muslim business arena and medical arena. And after 2007, the biggest push we was getting and request we was getting how to distribute our asset according to Islamic laws to our children's. And so we started doing a research in 2011. I hired a couple of attorneys, a couple of scholars to come up with the best possible solution for distributing asset according to Islamic laws and also complying with American laws. So this is my brief background. I came into financial field after sudden death of my father. So when we look at our, especially Pakistani Indian community, we have a shortfall of our future planning. So the whole goal was the pain and grief I went through it. We can possibly educate and guide and protect our families as much as we can. That is my brief introduction. I really want to appreciate all of your time coming in. And Dr. Naim Saab was, thank you to him that he organized the whole event. The whole concept emphasized on an Islamic state planning and why it is important for American Muslims. And what is a benefit? We have to do state planning according to American law anyway. But what is the benefit if we also include Islamic laws and Islamic Sharia distribution? We're going to start from a hadith. Prophet Muhammad said, learn the inheritance and teach it to others. It is a half of the knowledge and will be forgotten. The first thing will be taken away from my ummah. So that is one of the focus point, and we've been learning and teaching our Muslim community nationwide since 2013. What we're going to focus on, what is probate, what is estate planning, who needs a state plan, what makes Islamic, components of a state plan, and then we're going to go through question answers. And in brief, if there's I would like to have a more discussion basis. If there's a slide that anybody have a question, they can stop me and ask me a question right there, and we can answer. So why is state planning important? State planning is the decision that we have to carry on to distribution of our assets. This is a great comment we came up with, saying that what you don't decide, someone else will decide for you. And when it comes to your asset, your values, and your faith, you truly have a decision to the chance. So the main elephant we're going to focus on to destroy in this or discuss is probate. Probate is a process of distributing asset to the family. It is a court supervised process. It takes average about 3 to 5 months to about 2 years to complete all the process. And it is completely avoidable. and it's a agony, the pain the family have to face after somebody passing away. And the process of probate is collecting, taking possession of deceased property, protecting, preserving deceased estate, paying all the debt, all the taxes, determining who's entitled to the asset, distributing property according to the loss will. If there's no will, then state loss. Depending on the state to state probate, fees are close to 6 to 10% of your total estate. So it is time consuming and expensive, and it is the toll is going to take on the family after the death is horrendous. 4 reasons to avoid probate. Number 1 is unnecessary problem. Potential creditors hires. If somebody is going through probate, they have to post if there's a creditor against you or against your practice or somebody co-sign, they can come and claim their put a claim on your estate. It is delay, fees, legal court and attorney fees, and everything is public. There's no privacy in distributing assets. The process takes authenticating loss will and testament, posting bond, appointing an executor, personal representative, identify, notify the creditors, then also identify the death value, locating all the assets, paying all the debt, then preparing and filing a tax return, and then distributing the asset to the family. What is estate? Estate is a combination of your business, your house, your cars, your assets, your digital asset, life insurance, and all the retirement planning. And estate planning, what is estate planning? It is a comprehensive process of organizing and structuring an individual's asset and financial affairs to ensure their wishes for the distribution of the property and assets are honored upon their death. And as for the estate planning, essence, asset distribution, the main approach, a proactive approach to ensuring your assets are distributed to the beneficiary that you choose, minimizing taxations, guardianship decisions. If anybody have minor children, very, very important to have a guardianship system in place, ensuring privacy. Majority of the attendees are in the medical field. So in my practice contains about, in financial planning, about 85 to 90% are medical professionals. Is one of the highly vulnerable field that lawsuit vulnerability. So we have to protect all the assets from any potential lawsuit, any issues coming arising, and also ensuring the privacy. So being a high net worth, if there's no privacy, and if anybody can go and see so and so going through probate, and they can figure out all their assets, they can start coming after the families. So we have to create a trust, and in the trust we have to have a specific language to requesting a court and attorney to keep everything private. Reducing conflicts, health and financial decisions. Main goals of estate plannings are having a complete control over property while we are alive. What is that matter? In case we are in an incapacity, or if we have any medical scenario, we want to have a full, complete control of our assets and guiding, and all the assets, even trust and everything, need to benefit you and your spouse first, then the children's, and then everybody. Second, avoiding probate, take care of ourselves, give what we need, whom we need, and also the most important, being a high net worth, we want to save every tax dollar professionally and any court fees that legally we can. Also protecting children's, protecting inheritance from creditors. Disability planning comes in there, prevent delays related to state. I will go through some scenarios afterward to show you what is the difference between estate planning and having joint ownership, and also benefit of having a trust. A few mistakes we have to avoid while we're completing estate planning: having no plan at all, some forms or documentations from internet without any observations, incorrect beneficiary designations. Somebody went through a divorce and they never update, or if something happened, or if somebody is already deceased in the beneficiary, they never update. failing to protect assets from IRS, creditors, protectors, bankruptcy, and all the other issues. Giving young people or the heirs with the spindrift issues inheritance without any parameters. So spindrift issue is one of the very important article in being estate planning. Spindrift issue article and protection protects the beneficiaries as well as trustees from any creditors, any divorce proceeding, any court proceeding. It protects any assets under the trust as long as they're unintentionally ensuring your loved ones go through the probate, not having the right people in the right place who can, in case if you become incapacitated. Estate planning concept from Quran. So when we do the research in Surah Nisa, Ayah 5, Allah says, do not entrust the incapable among your dependents with your wealth, which Allah has made means of support for you, but feed them, clothe them, and speak to them kindly. And if we look at American system of trust planning or guardianship planning, this is incredible that Allah already told us in the Quran that we have to follow that. And then second ayah comes 6, and test the orphans until they reach marriageable age. Then if you perceive in them the sound judgment, release their property to them and do not consume it exclusively quickly, anticipating that they will grow up, and whoever, when acting as a guardian, is self-sufficient, should refrain from taking a fee, and whoever is poor, let him take according to what is accountable. Then when you release the property to them, or bring a witness upon them, and sufficient is Allah as accountant. So if we look these two ayahs in the Quran, this is a basic concept of proper estate planning for young children. If they're minors, we have to have a proper guardianship in a place. And the second most important thing for the guardianship is that children are the biggest asset we have after being Muslim. So we do not want to put them in a state foster system in case anything happened to husband, wife, or both of them together. Then we have to have a plan in place. Why we need to have a will state planning? Allah orders us in the Quran that it is prescribed, Surah Baqarah, Ayah 180, it is prescribed that when death approaches any of you, if they leave something of value, it should be made in favor of parents and immediate family with a fairness. This is obligation on those who are mindful of Allah. And then Surah Nisa, Ayah 7, it says, for men there's a share for what parents and the closest relative leave, and for women there's a share what their parents and closest relative leaves. Whether it is a little or much, these are obligatory shares. And when we have heard of everybody almost heard this or these, but this is the reason we have the Islamic concept in Quran and Hadith. This is not just a state planning, it's also part of our Islamic faith and Islamic duty that we have to fulfill. We have to pray every day, but this is also obligation that we have to fulfill as a being Muslim. Prophet Muhammad said, it is not permissible for a Muslim who has something to will and stay for 2 nights without having his last will and testament written and kept ready with him. Also, a second very powerful hadith, a man may do good deed for 70 years, but he act unjustly when he leaves his last testament. The wickedness of his deed will sealed upon him, and he will enter in the fire. And if another hand man act wickedly for 70 years, but is just when he leaves his last testament, the goodness of the deed will seal upon him, and he will enter into the garden of paradise. So why we have this hadith there? We get a lot of questions that if my son or my daughter or somebody in my family or beneficiary, we can take them out of our inheritance, or we want to disown them, or so we have to follow exact Islamic law and exact distribution system, and we cannot disown anybody in the beneficiary system. And this is the wasiyyah comes in that Prophet Muhammad visited Hazrat Saad when he was sick. And Hazrat Saad said that I only have daughters. Can I donate my property and my asset? They said no. And they said that how about half? They said no. And then Hazrat Saad said, how about 1/3? So Prophet Muhammad said that 1/3 is okay, but it is better for you to leave your inheritor wealthy than leaving them poor. So it is not mandatory for anybody to have a charity system going on, even though having a small percentage into your estate planning can be a long-term sadqa jariyah. And in our Quran also, Surah Baqarah ayah 181 says that whoever changed the will after hearing it, the blame will only be those who made the change indeed, and Allah is hearing. So sometimes if somebody already made a will and somebody want to change it, they cannot be changed. Second, if somebody had a mistake done in the will and distributing property without according to Quran or Islamic law, Allah gave us permission to correct those mistakes and pray for them that Allah forgive them. The whole concept of Islamic distribution system comes into two ayahs. All the calculations, regardless of your situation, it is in Surah Nisa 11 and 12. And Allah starts this, Yusikumullah fi uladikum. Allah commands you regarding your children and the share for the males and females and everything. And also on the bottom of the ayah, as a human being, the difference between a human and Almighty Allah in a justice. If I have a 5-year-old son and 80-year-old father, I technically will think that my son have to leave the whole life, and why don't just I give everything to him and not give anything to my father? Allah says there that you do not know who's more beneficial to you. So you have to distribute according to orders of Allah and according to the Islamic distribution system. Distribution percentage of our whole calculation in Islamic distribution based on these two ayahs. This is kind of golden ticket. We have to distribute our asset to our family anyway, but Allah says that these are the limits set by Allah, and whoever obey Allah and His Messenger will be admitted by Him to the garden in paradise, which river flow, abiding eternally therein. So this is the best golden ticket that we can think of. One thing we have to do for the family, getting a great benefit. And then the next step is Allah says that whoever disobey Allah and His Messenger and transgress against His limits, he will be put into the fire, abiding eternally therein, and he will having a humiliating punishment. We receive requests time to time that my sons and my daughters are here. I want to distribute equally, or I do not want to follow Islamic laws and stuff. So we have to guide them that it is your decision, but according to Quran, if you do this, Allah will also give you a benefit of following this. And then Islamic inheritance law basically focus on few things. The distribution order for distribution is funeral and burial expenses first. Any debt that we had, al-wasiyyah, which is 1/3 of discretionary if we want to give anything, and then the distribution. The debt is one of the worst things that we can carry on. So Prophet Muhammad's time, that one Sahabi passed away and Prophet Muhammad was asked to lead the janazah prayer, and they refuse. They ask if the person have any debt, and they say yes. So they refuse. They say you can carry on until the debt is paid. They did not perform the janazah. So main debt we have Islamically, that if there's any misforms or kufara or anything that we have to do. Other than that, mortgage, loans, and all that, everybody knows what debt, or if there's any amana that have. This is one concept which is very debated, allowed or not allowed, but life insurance in Islamic inheritance, one of the only financial instrument that can pay off any debt upon the death of person. So I have a personal discussion with one of the mufti from Medina University. He was a retired dean, and as for PhD in Islamic Wirasat, and I asked him, can we use the life insurance to pay all the debt? He said, yes, this is, if we use it for that reason, it is allowed. It is one of the best estate planning tool. If we look beside of Islamic concept, it can be there and paid off family. Family can be compensated and have enough money to go through the grieving time, as well as paying any taxes and any issues that comes up. The components in the estate planning is a lost will and testament, durable power of attorney, advanced medical directive or healthcare directive, living trust in most cases. There's two kind of trust, living revocable trust and irrevocable trust. I will give a brief information on that as well. So last will and testament used to distribute property to beneficiary use three purposes: distribution of property, having a guardianship for the children, and having an executor. Second, advanced medical directive outlines, healthcare decisions, medical support, as well. If we do Islamic concept, we have to have it there that in case somebody passed away, the burial need to be according to the Islamic laws and according to the Sunnah of Prophet Muhammad Sallallahu Alaihi Wasallam. Then durable financial power of attorney, somebody can act on behalf of another person in case of incapacity or traveling or any scenario. These are the main three components or three documentations every person should have, regardless of their wealth status or regardless of their scenario or their financial situation. Every document that we prepare, it is color coded so family knows which document is going where. We simplified every single thing. The packages have my cell phone number, contact information for our office and everything. And in case they have any scenario, they can reach us directly. Then we have revocable living trust, which comes in a comprehensive estate planning. Revocable living trust, last will and testament, which is called pour over will with a trust. This will is different than last will and testament. The main purpose of this will is to tell the court system that we want everything to be owned by the trust, and trust is our beneficiary. And again, medical directive and power of attorney. Then we have to have transfer documentations for the deeds and property transfer to the trust and all those. These are basic information that, what is a will, requirement of a will that we have to go through. Benefit of the will is that guardianship, personal representative, state executor, who's get what, and cons are must go through probate. Does not control joint owned properties, minimal tax saving.
Quick question I have. What is
Yes,
the
sir.
difference? What is the this is Nasrullah. What is the difference between advanced directive and a durable power of attorney? Is the
Sure.
durable power of attorney is just specifically for the healthcare, and then advanced directive is both the financial and the healthcare?
No. So advanced directive is every state have a different name for the advanced directive. Some state calls a living will, some call medical proxy, some call advanced medical directive. Some states says healthcare power of attorney. In case when you are hospitalized, you have to have an agent who can manage and who can take care of you. In the state of Maryland, it goes by the advanced medical directive. Virginia says living will, and every state have a different name for it. As for the power of attorney, that is a durable financial power of attorney that gives, let's say, your spouse or your family member about 16 different powers to control, to manage your assets while you are away or in a situation that you cannot handle.
Incapacitated or whatever.
Yes. So that handles financial, but the medical point of view is a medical directive, healthcare proxy or medical scenario.
Okay.
Good.
Okay. And is your firm have the capacity to handle all these different components: revocable trust, financial
Yes.
power of attorney,
Yes.
and advanced directive, as well as durable power of attorney? Is that what you guys do?
Yes, sir. And we also do financial planning as well. So we have a combination of estate planning and financial planning combination.
Okay.
So, and we've been offering these services since 2013.
And you are located in Maryland, did you say?
Yeah, I am located in Maryland, but we have attorney in Florida who works with us. We have attorney. Basically, every state have a different laws. So we have different attorneys in the different states that work with us, and we collaborate to satisfy our clients' needs.
Okay. Mm-hmm.
We do have quite a few clients for the estate planning in Orlando and a couple other, Florida-based clients. It's not the first time that we got approached by Florida.
Okay. And you are also have the experience of setting up the trust for the charity trust or whatever you call that.
Yes. Charitable remainder trust.
Yeah.
We can set it up charitable remainder trust, and we can also fund it with the annuity charitable remainder trust. And we have done that. So charitable remainder trusts can benefit somebody right away, and also some charities that you can put an annuity in there, which can actually over the life or grow the assets in there and distribute a percentage or the way you design into it.
So
That
and when you said that annuity, does that mean that that you have to invest X number of dollars to get an annual return on that investment, and then your original investment also grows? Is that what you're saying?
Yeah, so let me tell you a scenario that one of our client, he works with the World Bank. So he put it in, he said that I want to distribute $300,000 to charities.
Yeah.
But the way I want to do, instead of giving them $300,000, if anything happened to me, I want to invest this into a long-term investment vehicle, which could be annuity, and that pays to the charity 5% or 10% of the growth every year.
So and then what happens to your original annuity? Say you spend a $300,000 in buying that annuity, and now you're paying 5% or 10% to that trust to be
Yes.
distributed as a. What happened to that original investment that you did into the annuity?
Okay, so if we do it in a charitable remainder trust, charitable remainder trust is a irrevocable trust, and it is the only benefit to the charity. So upon the maturity, or it can, when you set it up, you can have a longevity that it can grows on for 10 years, 20 years, or 30 years. And
Okay.
upon that, it can either deplete the money or whatever left that goes to the charity.
Okay, so I'm a little bit confused. So when you say it depletes, because by what you are just describing is two contradictory concepts for me.
Sure.
One, you are saying that is going to pay 5 or 10% on the annual rate of investment on the annuity
Sure.
that you invested. So it should grow as a principle. It should grow while
Yes.
you are getting 5 to 10% of the return on the investment. So when you say it depletes, what does it mean? How it will get depleted if you're paying only 5 to 10%?
Sure. So your question was that what happens to the money in there?
Yeah,
So
but the original, the principle,
yes,
the principle that we invested for the
absolutely.
sake of this charitable.
Sure. So that's what I basically, when we design that, it's not a typical designing. For example, if I design an annuity for you, you put an investment in there that grows in there for 10 years, or let's say if you are in a retirement age, the lifespan of the payment will be the life of the person. And if there's anything happen to him, it goes to the whatever's benefit left goes to the family.
So what about the interest? Yeah.
Interest, basically, you take a percentage of whatever. For example, if you put $300,000 into investment,
Yes.
and but it is growing, let's say 7%. One of the annuity we have that grows 7% or 10%, and you deplete, taking out 6% of your of the assets. The assets are growing. So let's say if it grows to $1 million, and you only took out $300,000 in your lifetime, whatever's the leftover, that goes to your family as a death benefit.
Okay, but if you are leaving it in the charitable trust, then
Yes.
it goes towards the charitable trust.
Yes.
And in that charitable trust, you said that there is a life of the annuity. So are you saying that, say, if it grows 7% or 8%, just take any hypothetical figure, and then are you saying that if somebody is getting 5 or 6 or 7% of that money back into the charitable trust for whatever the objectives of the trust are, the rest of the money will grow and will, at the end of that life of annuity, the money will be returned back to that trust to be distributed according to the trust goals? Is that what you're saying?
Yes. So when you somewhat, so when you design the annuity process for the charitable remainders, then you design in a way that instead of 5% or 6%, you increase the percentage going to the charity every year. Let's say you set it up a plan that I want to deplete whatever I have in 10 years, right? So we design a plan accordingly that, instead of 5%, we pay 15% or 20% going to the charity every year, which is 5% mandatory, and on top of it, we are withdrawing extra payments. So it ends in 10 years. So one use the main benefit you getting as a charitable remainder trust is the tax benefit, that you get about 40% off your
Yeah, of
investment.
course.
Yes,
Yeah.
right away. So
Yeah.
you can have a charitable remainder trust with annuity. You can set it up with any assets that you own, and you can date it. Even, for example, if you have a house or land or something, that could be dated 100 years from now.
In
Some
your firm, you also work with the concept of an endowment fund for the sake of the charitable trust, where
Absolutely,
that fund
absolutely.
also grows the principal, and plus it creates some revenues on ongoing basis. Is that what you guys do also?
Also, we are actually educating our massages to set up an endowment fund
Yeah.
funded by planned giving.
Yeah.
And because they always complain, we need money for the running cost. And I say that, why don't you use planned giving, which is educating community members to put estate planning, or put percentage into their estate planning, and that funds the endowment fund to grow and pay for a couple of our masjid that we follow have $2 to $3 million each in endowment fund,
Yeah.
managed by the Monacare, Mana
Yeah.
Mutual. So
Yeah.
I know absolutely where you're talking about.
Okay. So you in your personal experience, you encourage rather the annuities or these endowment funds invested into those amana kind of investment vehicles to
Yeah,
generate more value for that trust?
it depends on the situation vices. So
Yeah.
I have a client who said that, after so and so, I have this money, I already set it up aside, I just want to take care of it.
Yeah.
As for the endowment fund, majority of our massages, they need to have a professional people to know. Some, mashallah, all of you are well educated and well. Our local masjid, they got donations to build a masjid last year, $1.2 million, and all
Yeah.
of the sudden the old responsible and mature leadership just went out, because they find out that they promised the community masjid will be filled in 4 million, and the cost to build is 12 million now.
Oh,
So they just new election happened, and everybody just backed out, and young people who don't even know what is financial planning and estate planning, and they are there to run it.
Yeah.
okay.
So
Yasser,
yes,
we'll
sir.
talk the masjid in a second. So that was endowment about the masjid. For our trust, if we have to make a revocable trust, we have to put all our deeds of any properties in that trust. We have to change the deeds.
Yes, sir. So go back to the main the topic we have. So when we set it up a trust, the trust have to follow all the deeds, all the assets that you own. That's why, remember, we talk about pour over will, which is a little bit different than a lost will and testament. The pour over will tells the judge that whatever a person owns, the trust is their beneficiary. That's a backup. But while you are alive, you have to transfer the deeds of your property to the trust.
One more thing I wanted to ask.
Sure.
Two actually. How much that transfer or deed, the time and the money would cost for each property, and if we want to keep the deed of the house combined with our wife, so to protect her, that her place of residence would be insured, is it Islamic that the house is left with the what do you call it, co-ownership, but the rest of the deeds are thrown into the trust so that
Actually,
she's protected
yes.
after your death?
Actually, let me answer the second one first. You can protect her rights to live in the house in the
Trust.
trust as well. We
Okay.
talked to our scholars. There's a big issue going on. A lot of two scenarios happened with us. Client passed away. His wife is living in the house, and the children are forcing her to sell the house. So we talked to our scholars, and they say that put a paragraph, or give a control that house to the wife until she's alive before the distribution.
And the other thing was that how much would it cost to transfer every
Yes.
deed?
So every county have a different scenarios. Every county have a different bylaws and stuff. So once we complete the state planning, we can give you the exact, uh, you know, point and process of that. So for example, in completing a deed and transferring, it costs about $400 to $500 per property to the trust. If we already have the trust created.
And we can transfer a property which is still under mortgage or have
Yes.
some. Okay, wonderful.
Because because you are the grantor and you are the trustee. So state constitution allow us to transfer the property without treating the pay and sale due clause.
Got it. Now, if there is a member who is in the family right now and inherits according to the Islamic Sharia, but
yes,
before you die, he or she passes away, then it automatically readjusts?
Yes. So the language goes on there that the percentages are there. The distribution need to be handled according to the fractions or percentage. So when, for God's anything happened to somebody, then it readjusts and other people will inherit from them.
What if I have an adopted child, and what do I do?
Okay, so luckily we are on the screen that points on, as an adopted child, they cannot inherit, they cannot be the beneficiary, but you can give up to 1/3 of your asset as a gift to them.
Thank you. Yeah, so you can go ahead with your possession.
Okay, yeah. So this is basically the 1/3 scenario we came earlier. Anybody that any charity, you cannot give more than 1/3 to a charity or any scenario or anybody out of the family. 2/3 have to go to the beneficiaries. Without a will, we have to follow the state laws. They have to utilize, it's a time consuming and non-Islamic and everything. And financial power of attorney. Again, financial power of attorney is a legal document. We gave advantage to person if somebody become incapacitated. Authorize a person to handle their financial affairs when you are incapable of handling yourself. Our revocable trust, legal document, the grantor created by grantor during his lifetime, bypass the cost and the time consuming of probate and enable the trustee to carry on their wishes, provide a set of instruction to care for your family during your lifetime and during incapacity and after that. All asset disposed via trust will not go through the probate. And a trust must be funded with the applicable assets. A few benefit of the trust, I'm gonna actually, yeah. So this is a main difference between will and trust. A will have to go through probate, takes time consuming, public disclosures, but the trust, once you create it, by the way, one small side scenario, as for the medical practice, the biggest asset practice have is their patients. As for attorneys, the biggest asset they have when they are trying to liquidate or sell their practice is how many clients are there for probate. So being as a financial planner, we can educate our clients that at the time of probate, you do not need an attorney to go through the probate system. Once we properly set up all the transfer and everything is handled by the clerical proceeding. And we have seen some wills and trusts that they are binding with attorney and telling them that they cannot use anything or they have to have our attorney's permission before even withdrawing or taking money out of accounts or anything. So
one thing, I'm so sorry to interrupt.
No problem.
If we have other businesses under other LLCs, can we put those LLCs in the living trust rather than changing the?
Absolutely. You
So
can
give you a second protection.
There's a two-way to doing that. You can have assignment of interest of LLC to the trust. That is one way to do a proper estate planning because depending on your scenario, if you want to avoid probate, you can avoid probate with the assignment of interest of the LLC or any corporation to the trust. If you have that document, it is private, it's to your family and yourself. The benefit of that is that, let's say if your business is on the loan, and if you have any medical practice or any business that you need to deal with the banks and loans or any scenario, if you show them the trust is the member of LLC, they have to go through, review all the trust planning. They have to uh, it is more time consuming, and it is more they create more issues on that. But you can have LLC owned by the trust. You can amend the LLC and put, if you already have a running, and put the trust as a member of LLC. But one of the best way to do is having assignment of interest of the LLC to the trust.
And you put all your assets, including your properties, 401k, insurances, HSAs, stocks, collectibles, and digital assets in the living trust.
So a few things. 401k and life insurance, trust can be the beneficiary of those. Trust cannot own those assets. Your collectibles, your stocks and all those accounts, you put those in there. As for the collectibles or gold or jewelry or anything, you want to have a detail. We have one of our medical client, and he loves artwork, and close to $300,000-400,000 worth of pictures, the artwork he have. So we want him to ask him to put a detail price and the description of artwork, that we can put it in the trust, that in case anything happened, they know. So nobody can actually misuse or give it somebody else.
Got it. Continue, please.
Yeah, sure. So the pros of benefit of trust is avoiding a probate, saves money long run, asset can be protected from legal battles and creditors. So one of the things we do on the trust is a name a different than my own name. So for example, if I set up my trust, I should not have a Yasser Zia and then Yasser Zia Living Revocable Trust. I should have ABC, or my father's name is Mustafa, so Mustafa Living Revocable Trust. Yasser Zia and Sadia Zia are the trustee, dated so and so are dated on the day of execution. The reason for that, if somebody searches my name, or if we search somebody's name in a public database, we figure out how many assets they have. But if they are trustee of a trust, it is a small shield that you're putting against your property, and you're protecting it from creditors or anybody put a lawsuit against you. You can protect to the limit with the revocable trust. The biggest con for the trust is retitling assets. It is cost more than upfront, and we have to create and maintain a record for it.
And the cost of making a trust, you have the other con. Do you have a guesstimate of how much it costs?
Yes. So basically, trust starts from close to $5,500. Trust basically comprehensive planning. It is trust, medical directive, power of attorney, transferring the asset into it. The cost is roughly between, we have lowest about $5,500 and all the way to about $20,000, depending on the scenarios and complexity of person to person.
Got it.
Small checklist is, and again, this is a one-time fees. The way we structure our trust is self-completing, that you do not need to have expensive probate process with the trust. Everything is maintained, and everything is self-completing at the time.
I have another quick question.
Sure, sir.
Is there any annual fees for
No.
the trust maintenance, for the IRS documentation, papers, and all that?
No, there's a unrevocable trust goes on your Social Security. You do not need a tax ID number for revocable trust, and hence we don't charge any yearly maintenance fees. We have a mandatory meeting with our clients once a year to go over, review if there's anything changed, if there's anything need to be amended. There is small cost when we need to do a lot of documentations change or amendments and amendment stuff. But luckily, so far we haven't had any chance that we charge any clients the high fees for that. But I have to say it could be a small cost, but nothing major. There's no annual maintenance fees or anything. This is a small checklist that a person should have it, estate planning for the children. Also for the asset, we should have asset and liability in a check. Recently, we had one of our pharmacist client passed away in Maryland, all of a sudden with a heart attack, and family didn't know anything. So even though the wife is doctor, but it took them almost 4 or 5 months before they can figure out everything in place and all the scenario. So we try to educate our clients that you have a folder, and the folder should be with all the important documents, all the scenario, all the bank accounts, everything, and you keep it in a safe for your family scenario, and people should know that where's everything is. As for
A question: who should be the ideal trustees? The husband and the wife, they die all of a sudden. Is the children, or do you suggest anybody from a circle of friends, an
Sure.
attorney friend, or how? What do you recommend to your clients?
So first of all, if you use attorney for the trustee, you have to pay
Should
them a
not be.
fees.
Yeah.
Yeah, you have to pay them fees. You can have you can also choose banks. You can choose any financial instrument. One of the financial company we work with, Mass Mutual, they can be your trustee, but they charge a fee.
Yeah.
Amana Mutual, they have a Saturna Trust Services. They can also be the trustee, but they charge a fee. So we always have a layer: husband, wife first. Then, if the children are capable of handling their financials, they should go on. Family members, brothers, sisters. If not, then if there's nobody, then a friend could be. One of my best friend is on my guardianship for my children, even though I have 3 brothers. So sometimes your friend could be even closer than your brothers. So, and vice versa, you can be on their trustee. You can complete a plan or complete a executing plan that the both family have understanding and both family can take care of. One thing you should consider, if you have a children's, they are in a lifestyle, a person who is taking care of them should be honest and should be okay standard, or stable in their financial, so
Yeah.
it does not deplete your asset from the children. And we can, if there's a minor children, we can establish a sub trust inside the trust that protects their assets from somebody.
And is there any phase out 5 years, 10 years down the road, or like 20 years, 30 years? How do you usually structure those trusts? The parents are in 70s, 80s, 60s, and then the children will take over. How do you phase out those trusts in
So
terms of
it
the
depends.
timeline?
Yeah, it depends on the family situation. If there's a mentally incapacity, if the person cannot handle their financial affairs, then the children's, whoever's the next trustee, can have 2 medical doctors
Okay.
examine the person, give a charge sheet, and he becomes a acting trustee on the trust. So
No,
if
I think my
somebody,
question, no, my question was like you leave the trust, you are the trustees, and then your
yes,
children are. But beyond the children, but once the children are, I think they can make a decision how long they want to continue and how they want to distribute the funds
absolutely.
out of the trust. I think that's my question.
Yes, absolutely, on that scenario as well. But if you are setting up it's a revocable trust, and when
Yeah.
you set it up for children, for example, if you want to deplete all the asset, if they're receiving a house, they
Yeah.
have the house within 5 years, they distribute it, then they don't need the trust anymore. But if they want to carry on, they can carry on the trust. Some trusts been carrying on in the United States for all these uh, Ford or all the wealthy
The
people there.
Rockefeller kind of guys.
Rockefeller Trust, their
Yeah.
trust been
Yeah.
their 10th generation grandchildren know that who's their great grandfather is.
Yeah. Yeah. Their
So
children are contributing into that trust.
yes, absolutely. So the trust
Yeah.
can be whoever's a
Yeah.
trustee, they can also manage, they can also take
Yeah.
care of it. One of the thing is any asset that inside the trust, for example, if the children are going through a divorce scenario, any asset that's under the trust is protected from the divorce scenario as well.
Oh. Okay. Okay.
So that is one issue going on these days in a community beside if the wife is the only one, and she need to be secure in the house.
Yeah.
And beside the estate planning, we offer, the comprehensive financial services, from a college planning all the way to retirement planning as well.
Yeah.
So
So what is next? What is next now? We will have your email, telephone number. Get in touch with your company, and you will assign a person to walk us through all this thing. Get in touch with different specialists in your company. How does it work out?
So basically, when we set it up timeline, we need to go through a one-on-one meeting, or whoever's ready and whoever decide to give us the honor
Proceed further.
give us the honor to serve their family. Then we will have basic information, basic interview, that what exactly they need, what is their scenario. And personally, I do not want to, if somebody only need a will, I will not force them to have a trust on it. But if we go through it, once we have that, then we request some documentations that we need to fill, and then we proceed with the completing of a trust. Then we utilize the attorneys in state to collaborate with them to transfer the assets to the trust property. Few states are very tricky, which is Florida, California, and New York State, that we have to be very careful when we transfer the asset to the trust.
Yeah.
One more thing, Yasser, can you share these films which you just showed this PowerPoint with us? Is it possible?
I will send you the recording of information. Do you want me to share the whole PowerPoint presentation?
If possible, yes. If not, that's fine too.
I can try to send you. These are just basic information that we go through it.
Okay.
Yeah, no problem. I can share with Dr. Saab, and they can forward you. But
because most of us do know what we own, and we should at least gather the stuff which needs to be transferred and what we have to make a worksheet before calling you, rather than starting from scratch after the call.
Absolutely. So regardless, if whenever you have a meeting, the most important thing is that we have all the assets in a line, and the family knows what's going on and where everything is.
Yasser, do you recommend the children to be on that conference call when you're setting up the trust and living will and all that?
We have both meetings. We have the children's as well as without them as well. So depending on the children's situation, if they're financially savvy, if they know what's going on, but if they're minor, then they don't need to be. But if they are
adults,
definitely.
Yeah, usually that's what I heard, that is recommended for the children to be on that.
And as for adult children, if they are in a college or scenario, if there's a going, if they are living away, the one document they should have, even though they don't have any asset, they should have advanced medical directive in place.
Yeah.
Okay. One thing you already told me, I just want to reiterate. So if the distribution in the trust and you die, so it will be distributed to those people, or it will remain in the trust? Because if one of the kids get divorced, they will not be. I mean, that will be protected from going to the
spouse will not be entitled to any proceeds from the trust. That's what you're saying.
The property will be in the trust until they decide to take that out. So we can set up a structure. For example, if there's a life insurance, $1 million life insurance, and if somebody's already making $100,000 or $200,000, and all of a sudden they receive their share of $400,000-$500,000, then they have to pay income tax on that, regardless of the state tax. But when we structured it, or when the trust can have the money, invest anywhere, but systematically withdraw from there, also benefit the people who are taking it out.
Great.
But that's an excellent presentation, Yasser. I think we have.
I'm sorry, Nasrullah Saab, I think.
No, but I'm saying it's absolutely fantastic. I think the information that we got, and I think most of us probably never have gone through this path yet. So it's very informative. I'm just
no problem, sir. I really appreciate your time. And as far my goal and my sincere क्या कोशिश है कि when you read that hadith that learn the inheritance, so I made a mission for myself that I have to focus on it and have to carry on. So
Inshallah.
Alhamdulillah, so far Allah have blessed us and we've been serving a lot of families. We saved some families from the disaster. We saved recently a girl's inheritance. The uncles was trying to diffuse her or trying to convince us that it's Islamic not to give orphan niece $1.4 million because her, when she gonna marry, her in-laws gonna take her away. So we alhamdulillah intervene and she and her mother received that. A few other scenario, alhamdulillah, this is a part of I think it's a sadqa jariyah from our side that we can help our clients to distribute their asset to their children according to Islamic laws.
And we thank Naeem Adar Saib
Thank you very
for
much.
arranging this thing.
No,
Please.
sir, really appreciate it.
Thank you. Jazakallah.
Thank you so much.
Thank you. Assalamu alaikum.
Thank you so
I will
much.
get back to you.
I will send the recording in a few days to Naeem Saab and then they can forward to you guys.
Jazakallah.
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 Thank you so much.